Paez. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. Thank you for appearing for the second argument before the 7th Court of Appeals this January 8th day of 2025. Appreciate your attendance. If you drove up this morning, my condolences. If you came in last night, that was probably the smarter move, but either way, you're here, so we thank you. We'll go on and call the case. I know the counsel in these cases have argued in front of us before, so you're familiar with our procedures, and we'll dispense with general admonishments. So we'll just go on and call the case. 0724-00050-CR Alfredo Paez versus State of Texas for the appellant.
Alexander Nunez for the appellant, President.
Thank you very much. And for the appellee.
Jeff Ford for the state, President, ready?
Very good. That said, Mr. Nunez, it's all yours. There is water there. If you think you're gonna get caught in that, whatever, go on and grab a bottle of something there in the podium. Mr. Ford, you too as well?
May it please the court?
Counsel.
My name is Alexander Nunez, represent the appellant Alfredo Paez Jr. in this case. We present 7 distinct issues for this court's review in this case. This case is an appeal from a conviction of 2 counts of aggravated assault and 2 counts of deadly conduct.
Those 7 issues, many of them are interrelated.
Yes, Justice. So
based on double jeopardy, and depending how we act on double jeopardy, a number of them go away.
I think the double jeopardy, the issue with the jury charge related to the submission of 7 counts, and the issue with the probation is closely tied to double jeopardy. I believe the self-defense sufficiency issue, the 904 defensive instruction in the jury charge, and the informal verdict of acquittal all stand on their own.
How about the ineffective assistance?
The ineffective assistance also falls with the double jeopardy as well. Yes, Justice. So if I could, I'd like to address the defensive issue first. I think the 904 submission in this case is an important issue. In this case, Mr. Paez was charged with aggravated assault by threat. He was charged with 7 counts, with the conduct being the same in each count. And Section 904 explicitly applies to threats of deadly force and is incorporated into the overall self-defense theory. It's not a separate issue to be submitted. So when the court submitted their charge to the jury, there should have been either an instruction under 904 that the appellant just had to justify deadly force, or there should have been a fact issue decided by the jury that was appellant's purpose in threatening deadly force limited to creating an apprehension that he would use deadly force if necessary. And in 904, I believe in the state's argument is because he actually fired the weapon and didn't merely produce the weapon, then 904 would be inapplicable.
Reading the briefs, questions arose. 7 counts, 3 acquittals. Those acquittals pertained to assaulting the kinfolk members.
Yes, the acquittals were for Eddie Schmidau, Max Gould, and Michael Roberts,
The 3 kinfolk.
which were, well, Walter Goodman was also a kinfolk member or associated with that group in that.
Allegation is kinfolk started this.
Yes.
Since that was acquittal, those 3 were acquitted. If there were a mistake regarding the justification defense and the charge, there'd be no harm with regard to those 3, correct? You won.
As far as those 3 go, yes,
Okay.
yes. And I guess the issue becomes, would the other 4 have been justified in the use of force rather than deadly force?
Okay. And the other 4, who are they?
So Walter Goodman is an individual that is over there with the gentleman that draw the pistols and point the pistols out the front door.
Mhm.
And the other,
Mr. Goodman have a pistol?
Mr. Goodman didn't testify at trial. I'm not sure.
Was there any evidence to indicate that he engaged in a further act indicative of maybe having some type of weapon or that he was going to cause harm?
I believe based on his association with the individuals and being in close proximity to several individuals that had produced firearms, it's not unreasonable to say that he may have also had a firearm,
Did-
but there's nothing in the record to affirmatively
Is
demonstrate.
there anything in the record to indicate that he was wearing colors as well, kinfolk colors?
I
Or was it
believe-
just that he was by the kinfolk?
I believe there was testimony that he had arrived there with the kinfolk, that he was sitting there as hanging out with them.
Okay, from the perspective of your client though, was there anything that any evidence in the record from that your client would perceive that would lead him to believe he's with them, other than he may be sitting there with them?
I believe there was some exchange of words. I think there is some testimony that Walter Goodman was exchanging words with the other members of the banditos that had entered the bar with the
Exchanging
penguin.
what words?
I don't think there's a clear.
What
clear
person was
record.
exchanging words too? So does that mean she was involved with the kinfolk too?
No, but I think there is testimony that Walter Goodman was that he knew Michael Roberts, Max Gould, Eddie Schmidow, Misty Searcy, Danny Gollihue, that were in that corner, and that they were all there together for all intents and purposes. And when the altercation occurs, Walter Goodman is standing next to those individuals, directing his attention towards the banditos.
So as far as you remember, other than exchanging words, you don't recall any other evidence, and of course, we'll look at the record, but you don't recall any other evidence indicating that he engaged in some type of action that would cause your client to fear for himself.
I think in State's Exhibit 2, you see that he's that's the video, and I believe you see that he's yelling what appears to be yelling at the other individual, Mr. Lopez. And I guess the self-defense issue here was submitted on two different theories. It was either justified as self-defense of appellant himself or self-defense of Joe Lopez, who was the individual that had the gun put in his face and then walks out and was the only person actually shot in this, or that was shot that didn't have a gun. I suppose the testimony in trial showed that the kinfolks, I guess, shot themselves or
Okay.
shot each other.
Other than Walter, the remaining victims, they were employees of Copper Caboose,
Yes, Justice.
and did they engage in the action that placed your client in fear?
I don't believe so, Judge, but I also don't
Would
believe
they
there.
be entitled then to a justification defense with regard to them?
I don't believe those cases should have even been submitted to the jury, as each one of those witnesses testified that appellant never threatened them, never pointed the gun at them, never directed any assaultive behavior towards them. So the court did submit a justification defense on each of the 7 counts.
Exactly. So are you saying then with regard to the employees who were victims, any error in the justification defense would be harmless concerning them?
Well, I believe there was some evidence that force was used by, I guess it would be Mr. Decker, Grayson Decker, walks up and attempts to, or he says, hey, you need to leave. The showing of force versus the showing of deadly force is a stark difference. And so in order to
And
justify,
who's Mr. Decker?
that was one of the individuals in the bar. He was the bartender
He was the bartender.
the waiter server that night.
So a bartender going up and saying, don't want any trouble, you need to leave, that would, in your view, justify a self-defense or justification?
I think that may be a use of force to an extent if you're walking up to
Was
somebody
it
and
just words, or did he actually engage in a physical activity to get him to leave?
I don't think he physically touched the individuals, but when he walks up towards the individuals and says, hey, you need to leave, I believe that is a show of force.
In the
some cases.
videos, is Mr. Decker the one in the white top?
Yes, Mr. Decker is the individual in the white. The Terrence Wade is the victim in count one. He is the individual that comes in the back door. And Kristen Cowling is the victim in count three. She is the manager that's by Mr. Decker when the shooting occurs. But I think this also goes into the self-defense issue in that Mr. Paez was charged with engaging in conduct. He was charged with a nature of conduct offense. And in order to justify that conduct, he wasn't directing that conduct towards any of the three people that worked at the bar. And it was pretty clear from the state's theory that they didn't believe that he directed any assaultive conduct towards them either. He was reckless in putting them in danger when he assaulted the other people. So I think that goes to the double jeopardy issue of how many times did he have to justify this conduct? And if he had to justify it one time with respect to the individuals that did produce firearms and were the target of appellant's assaultive conduct, which I believe there was some evidence that Walter Goodman was involved. Again, Walter Goodman didn't testify at trial, which it has its own issues associated with it. But I believe there is harm in that a jury could have found that there was a use of force either by the managers or by the bartender that justified a self-defense under 931, not 932. The case points to, or the state points to several cases. And I think the important distinction is that in section 904, the language is produces a firearm or otherwise. So the statute contemplates more than just the production and threat of a firearm by the production of the firearm. So I think that doesn't foreclose the applicability just because appellant did use the firearm. I think that's a good segue into the verdict issue that we have, or I'm sorry, the self-defense sufficiency issue as well. Sort of ties into that issue as far as if they found that his conduct was justified, which portion of his conduct was justified and which portion was not. It's impossible to tell based on these verdicts in that he was justified in some of it, or he was justified with respect to these people, but not to these. But it's the same conduct that was justified. And when appellant came, he stipulated at the beginning of trial, yes, that was me in the video shooting. There was no testimony elicited that would have.
Why couldn't the jury parse out? He's justified with regard to the conduct vis-a-vis the people who clearly evinced a threat. Assuming arguendo they did, the kinfolk. So they acquitted them. The bartender, the others who were there, except maybe for Walter. Why couldn't the jury say they didn't pose any threat?
And I think the testimony or the evidence at trial was pretty clear that appellant didn't threaten them. And the state's theory of the case
No,
was
but to be justified, the victims have to pose a threat, don't they? Of
Yeah.
some sort?
yes, and I think
So why couldn't the jury say that the victims, other than the kinfolk, pose no threat? So that's why they found justification with regard to the kinfolk and not the others.
and I think that again goes back to the double jeopardy issue of how many offenses were there here? How many
Opposing counsel
offenses
says with
occurred?
regard to that, assault, each assault is a separate unit of prosecution. Is that right or wrong?
As
in your
far,
view?
it depends on the underlying assault. So there's 4 ways of committing an aggravated assault based on the predicate assault and the aggravating factor. So you can have bodily injury with a deadly weapon. That would be each victim. As the Court of Criminal Appeals has said in Garfield, there's a distinction. When the result is bodily injury, each victim is a unit of prosecution.
Okay.
But in a nature of conduct offense, which when the underlying assault is an assault by threat, the unit of prosecution is the type of conduct engaged in.
Type of conduct. Is a deadly conduct a nature of conduct or a nature of result?
So deadly conduct by discharging a firearm is a circumstances surrounding the conduct offense. In that case, it's criminalized because you engaged in certain conduct in the prohibited circumstances. And so each
Would that
instance,
compare somewhat to assault by threat?
I
If you're saying it's the conduct as opposed to the result?
no, because there's an additional element there. There's an additional element that the conduct is engaged in circumstances that create an unreasonable amount of danger. And so the Court of Criminal Appeals said each time you engage in that conduct in those circumstances, that's a separate unit of prosecution. So, but deadly conduct,
But why couldn't each time they fired be considered a threat?
I believe because it's the nature of the conduct. If the state had charged
Conduct
him,
is, the threat comes from firing, correct?
yes,
Deadly conduct, each time you fire, that's a separate unit of prosecution, according to the case law. Why wouldn't that be the same for aggravated assault by threat? Because the threat is each time you fire.
because it's a different gravamen of the offense. The gravamen offense of deadly conduct is the circumstances surrounding. The gravamen of the offense of aggravated assault by threat is the nature of the conduct. So we punish the conduct itself. And each
Why are you
individual,
punishing the circumstances surrounding
you punish
in
for each,
deadly weapon and deadly conduct?
you punish for each time they engage in the conduct within those circumstances. So it's a separate charge.
I think I'm gonna ask the exact same question, but phrase it differently. So if he actually hits all 7 people, no issue for you here, because it would be 7 different units of prosecution because 7 different people were hit.
Yes, and that makes sense because there is a marked difference between being shot and having a gun pointed at you. And there's a difference in harm. If there's 7 people that are shot, that makes sense that you should have to justify each individual person that was injured.
So if I point a gun at Mr. Ford, at you, Mr. Reese, at my staff attorney back there, and I am a bad shot. Boom, 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 boom. That's deadly conduct and assault you. That's just one offense.
I
In your
think
view.
I think it depends on what your intent was. Did you intend to point, when you pointed the gun over here, did you intend to point it at this individual? Or did you intend to point it, there has to be an intent behind the threat. And I don't think there was any intent behind the threat with respect to the first 3 victims. And that sort of brings us to the issue again of,
You cited a case that said that depends on the intent. And that's determinative of whether or not assault by threat, unit of prosecution is 1 or each time fired.
it would have, it's the nature of the conduct.
But did you cite a case indicating that, or are you just extrapolating from what you think the law should be?
As far as the offense being a nature of conduct offense, or
No, unit of prosecution.
the unit of prosecution comes from the Garfias case, from the Court of Criminal Appeals, and that's where
And
they make,
just talks about it depends on the intent
no,
when you're committing the assault by threat.
no, Garfias talks about what the gravamen of the offense is, and what we apply the mental state of intentionally or knowingly is to the conduct, engaging in the conduct. Versus bodily injury, assault by bodily injury can be reckless. You can't recklessly threaten somebody you can't recklessly threaten somebody in an assaultive manner. That's not a mental state in the statute. So there's a difference between causing injury and threatening injury. And you can't, I mean, Mr. Paez may have recklessly threatened the 3 people that work at the bar, but he didn't intentionally or knowingly threaten them. And there has to be some sort of intent there. And I think it was clear that Mr. Paez intentionally engaged in the conduct, which he admitted to. He said, yes, that was me shooting on the video, but it was justified because these people were producing firearms, et cetera, et cetera. So there's not a case directly on point, but it's based on the gravamen in the offense. Now, deadly conduct with misdemeanor deadly conduct is a nature of conduct offense. And so that again falls into the double jeopardy issue again with deadly conduct and aggravated assault, in which part was deadly conduct, which part was aggravated assault. So I think there's another issue there as well, because that also goes to the jury unanimity issue. I think at the charge conference, the defense asked for the state to elect which portion of conduct was directed at which they were alleging was each count. The trial court refused to make the state do that. So we don't know which portion they agreed on. If they said, yes, this is where we found he threatened Mr. Wade. This is where he threatened Mr. Goodman. This is where he committed the deadly conduct against Kristen Cowling. This is where he committed another deadly conduct separate and discrete against Grayson Decker. But it's all in the same 5-second span of discharging the fire.
Were all the victims in the same general area?
So victims in count 4, 5, 6, and 7 were in the same general area in the video. The victims in count 1, 2, and 3 are along the bar, sort of in line with, I guess if I'm looking at you, they're standing here. The other group is sort of off to the right where Mr. Yarborough would be, or Justice Yarborough would be. Apologize. I would like to address the, I'm sorry, I apologize, I'm out of time.
You do have 5 minutes.
Thank you.
Any
Okay, please, court, counsel. When is the assault victim not a victim? That is the overarching question presented in this case. Appellant argues that multiple people are threatened with imminent bodily injury, but no bodily injury is actually inflicted. There can be no more than one conviction. The appellant's argument, taken to its logical conclusion, is that if somebody shoots like a Star Wars stormtrooper, there could be no more than one victim, regardless of the number of people who are actually threatened with imminent bodily
one
injury.
victim prosecution purposes.
Yes, Your Honor.
Maybe number of victims, but the law only recognizes one prosecution.
Yes, Your Honor.
Is there ever a scenario where does the case law afford opportunities to have different calculations for units of prosecution? Or is it, no, we figured out what the gravamen is, and this one is everybody was shot, so the units of prosecution are each victim versus the crime itself? Can you have a mixed units of prosecution?
We can, I apologize.
And I may have phrased it poorly. Normally, whenever we're trying to figure out units of prosecution, we look at the gravamen of the offense. So if in a hypothetical scenario, if everybody was shot here, it's clearly 7 different victims, 7 different units of prosecution. Other scenarios where if they're not all shot, like the appellant is arguing, maybe there's just 1 unit of prosecution. Can we have mixed units? Where maybe we do look at it, maybe it's somewhere in between, not all 7, or maybe there's 3 units of prosecution here or something. I don't know if that's possible.
It's certainly possible for other offenses, and I'll admit I haven't really thought about that, but at least for the offense aggravated assault, whether committed by threat or by causing bodily injury, the unit of prosecution would be each victim. Now, it's certainly possible for some other offense. It could.
I noticed that you cited a case in your brief that said the unit for prosecution for aggravated assault is each victim. Do you have a case that says that applies when it's assault by threat? Because opposing counsel says really intent, and I may be misinterpreting what you're saying, but intent to determines what the unit of prosecution would be then.
Your Honor, and it's admittedly it isn't a CCA case, it's an Eastern Court of Appeals case, but I cited the case of Marson v. State, and that's 556 Southwest 3rd 924. It's an Eastern 2018 Court of Appeals case. That said, we adhere to the aforementioned cases and hold that the allowable unit of prosecution for the aggravated assaults, and in that particular case, it's aggravated assault by threat, not by causing bodily injury, with which appellant was charged as each victim, not each discharge of the firearm. So that's the closest case I was able to find directly on point for an aggravated assault by threat offense. Now, of course, there is also the ex parte Hawkins case, and that is a CCA case. It's a aggravated robbery by threat case, but that is one where they also found that the allowable unit of prosecution for a threat offense, which was each victim that the defendant had assaulted, had threatened, even when the underlying assault was by threatening each of the victims with a firearm as opposed to causing bodily injury.
Okay.
The gravamen, of course, in a same statute, same subsection analysis, the question will often devolve into a determination of what the allowable unit of prosecution is. Oftentimes, they'll be on how many victims of the identifiably defined offense there were. In a aggravated assault offense, whether committed by threat or by bodily injury, will be on each victim, because a threat offense focuses on the personal security of the victim, while bodily injury offense focuses on actual harm inflicted. So either way, whether the offense is committed by threat or by causing bodily injury, you still can consider each individual victim. And going back to a point that Chief Justice Quinn made, if somebody is a terrible shot, if I'm firing out of the audience right here, and I'm only intending on hitting one particular person, but I'm just a terrible shot, I just spray bullets everywhere there and don't actually hit anybody, the personal security of each individual victim has still been threatened there, regardless of whether I only had the actual intent to hit one person. So therefore, each person in this audience here, all 5 people in this to the right of me, would be individual victims and would have individual counts, as opposed to just being a separate manner and means of committing the same offense.
Thank you.
So what does the evidence in this case show as to how many units have been shown? Appellant threatened multiple victims in the restaurant with imminent bodily injury, warranting separate convictions for each victim. The indictment alleged seven different offenses, 7 different victims, not 7 different manner and means of committing the same offense. Neither face of the indictment nor the evidence establishes that appellant has been repeatedly punished for the same offense in a single prosecution. Turning to appellant's legal sufficiency challenge, the evidence was sufficient to find appellant guilty of the first, second, third, and seventh counts of the indictment. As Mr. Nunez stated in his argument, those would be the restaurant employees and Walter Goodman, the kinfolk member who did not participate in the offense. With regards to Terrence Wade, Kirsten Callan, and Grayson Deckard, they were all threatened with imminent bodily injury when the appellant was firing very close to them. In Terrence Wade's case, Wade saw appellant shooting, and that appellant was shooting very close to him as he ran from the scene. In Kirsten Callan's case, she dropped to the ground because of gunshots fired from the doorway and was afraid of being shot as a result of her position relative to that of appellant. Grayson Deckard's case, appellant shot in Deckard's direction. And finally, in Walter Goodman's case, yes, he was a member of the kinfolks, but he was not participating in that. Unlike Danny Gollihue, Edward Schmental, and Max Gold, he was not firing back. He did not know evidence, at least, that he even had a weapon there. Instead, what he was shown on the video, ducking down and hiding like he's in fear of being shot. The jury verdicts were not irrational when the jury convicted appellant of the counts of indictment, the aggravated assault by threat, and the deadly conduct counts. Inconsistent verdicts are not irrational when the evidence is sufficient to support each finding, and the verdicts are based on the cumulative weight of that evidence. That then shows that the convictions were based, that he clearly was not acting in self-defense with regards to the victims that there were
Would
actual
you consider
convictions.
these verdicts inconsistent? Even though you're saying inconsistent verdicts are not prohibited, would you consider the verdicts inconsistent?
No, Your Honor, I would not, because we don't know that, of course, appellant has presumed that the jury found that the jury acquitted on the basis of self-defense. We don't know that.
The 3 counts resulting in acquittal, they involve kinfolk, correct?
Yes, Your Honor.
Was the evidence that those 3 individuals, kinfolk member, were shooting as well? Or was only one shooting? Or is there any evidence with regard to any of that?
I know for sure that some of them, I'm not positive right now whether all 3 of the kinfolk members that they acquitted on were shooting, but I know they all had firearms.
You don't know that with regard to Walter Goodman or Goodman?
I have no evidence in the record that he had a firearm. And Your Honor, with regards to the argument on whether they acquitted on self-defense here, this isn't like the George Strait song, check yes or no. There was no check yes or no on whether you find self-defense or not here. There's only, do you find the appellant guilty of the offense, or do you find the appellant not guilty of the offense with regards to those counts there? It could have been that they acquitted on the basis of mutual combat there. It could have been that they acquitted on the basis that everybody that they believed was playing or participating in the exchange back and forth there. The jury didn't feel like there should be convictions on those. We simply aren't aware of why they actually acquitted on there. But as long as the verdict is rational and the evidence is sufficient to support each finding there, even though there were some acquittals and some convictions there can still be the arguably inconsistent verdicts and still have convictions for those, and that still be legally sufficient for those. Your Honor, turning to the court's charge issue, the trial court appropriately instructed the jury in the court's charge on the law of self-defense and to base any self-defense justification on the use of deadly force here. Under section 9.04, and an instruction on that the apprehension of deadly force does not constitute actual deadly force. It's only appropriate when there is evidence that there was a apprehension, that there was a threat of deadly force here. The evidence shows that deadly force was actually used. Used here. The evidence shows that appellant did not brandish his firearm in a threatening manner or announce that he had a gun and would use it if necessary. Instead, after pulling his gun out, he attempted to hide it as he passed by someone before beginning to fire it. The first time he created an apprehension was in he fired the gun. As before then, nobody was aware he had pulled it out. In fact, evidence shows that while the other bandito member was provoking the difficulty there by messing with kinfolk members, Mr. Paez was setting up in one spot, and then he initially found a better spot there from which when the difficulty was provoked there.
Is there any evidence in the record indicating that there was a plan to provoke by the banditos? Because they knew the kinfolk were there, correct?
Yes, Your Honor.
There's evidence showing that.
Yes.
One of the banditos goes up and engages in provocation, supposedly.
Yes, sir.
Okay. In discussing the fact statements or reading the fact statements, there's discussion about how the banditos worked together. Mr. Paez was an influential member of the banditos, had problems with kinfolk as well.
Yes, Your Honor.
Banditos had problems with kinfolk. Is there anything in the record to indicate that Mr. Paez and the other bandito who went up had a plan that it occurred?
Yeah, I don't have any evidence that they actually had a plan going into there, except that they knew that was their regular haunt, where they regularly hung out at. Their banditos outside of the restaurant there. The other bandito member went up there, took the pool ball there and said, "You're I don't remember exact words. It's something along the lines of you're either going to give up your cut or die for it." There. While this was happening, Mr. Paez was looking for an ideal place to set up basically.
Set up what?
So I believe set up once the difficulty had been provoked, there pull out a gun, have it by his side there, and have it ready to go.
Was he setting up as his fellow bandito approached the kinfolk? Or did he set up after there was a shot fired by the kinfolk?
He had already set up from what I remember with the record, he had already set up before the kinfolk member had fired his gun there. He had set up an ideal place there from which he could shoot at the kinfolk. And of course, you can't only consider this an offense. You have to consider the events leading up to this.
I understand. I'm trying to think of it. Of course, you're not entitled to justification if you provoke, correct?
Yes, that's correct.
Okay, if it's clear that one provoked, but there was somebody else there who knew he was going to provoke and was ready with a gun, is he entitled to justification?
I'm sorry, are you talking about Mr. Paez or the other
Mr.
bandit?
Mr. Paez didn't get the pool ball and
Correct.
go and say relinquish or else the other one did, but you're saying Mr. Paez was setting up
Yes,
while the other one did that.
yes, sir.
Could the jury have said, and I don't know if the jury was charged on, you don't get self-defense if you provoke. I have to read the charge, but could the jury said it was a big thing now in all political realm, there's no big conspiracy, everybody was planning to do this anyway, that the two of them were planning to do it anyway?
I don't.
Thus, he doesn't get a justification defense because he was provoking.
I don't remember if the jury was actually instructed on provocation. I don't specifically remember provocation in there, but I do believe that they were acting in concert with one another to basically mess with kinfolk members and place them in a position where they felt like they needed to draw their firearms.
There's evidence that they were acting in concert and there was a mistake in the charge. Would evidence of acting in concert go to harm? If they're acting in concert, did they both provoke? And thus they wouldn't have been entitled to instruction anyway.
I believe it could be part of harmless error analysis. Yes, Your Honor.
Okay, I'm just curious. And I'm saying the instruction was wrong or wasn't wrong. I'm just, as you know, we play devil's advocate.
Of course, yes, sir. And in fact, I do believe that, assuming that it was error not to have a 9.04 in instruction, I believe the error would be harmless. It would be a some harm analysis. But I don't believe that the jurors would have considered it because they determined that appellant used deadly force when they found him guilty of aggravated assault with a deadly weapon in the first and seventh counts, and found him guilty of deadly conduct in the second and third counts of the indictment. Turning to the fourth issue about whether trial court erred in accepting the jury's guilty verdict for the first count of the indictment. The trial court did not err in accepting the jury's unambiguous guilty verdict for the first count of the indictment. Although the jury foreperson signed both the guilty and the not guilty verdict forms, the latter had the signature and printed name scratched out and the name void written on it. There's nothing speculative, inconclusive, or ambiguous about the use of the word void on the not guilty verdict form. And finally, turn to the fifth issue here. Whether the trial court should have placed appellant on community supervision with respect to all the offenses when the jury recommended community supervision as to one of the offenses. This court has expressly found in the Drain case, and that's a 2018 case from this court, that the trial court has the authority to assess a split sentence of both imprisonment for one count and community supervision for another count, arising from multi-count case. So the jury did have the authority both to assess imprisonment and to recommend community supervision. In your honors, I see I only have 2 minutes left, unless the court has any further questions. I'll rest on my brief.
Thank you, counsel.
Thank you.
Mr. Nunez?
May it please the court? So
Real quick, with regard to the jury verdict that was struck, written void, was there a need to preserve that for review? And if so, was it preserved?
I don't think there was a need to preserve it. A verdict is a fundamental part of the criminal process, and there was no way for appellant to preserve it. If appellant had known that the verdict was informal, he would have objected and he would have put, there would have been arguments made, but the
But
trial
there was
court.
an opportunity to poll the jury, correct?
Yes, yes.
And nobody wanted to poll.
Based on the assumption that the trial court had accepted verdicts in accordance with the Code of Criminal Procedure, based on the assumption that a trial court has a duty to reject informal verdicts and bring it to the attention of the jury. Based on the fact that the trial court did not reject the verdicts, defense counsel is reasonable in assuming that the verdicts were formal and that there wasn't two verdict forms signed on one
But the
count.
trial court's accepting the verdict does not preclude anyone from asking for a poll, right?
No, it doesn't. But I think it's still,
Was there could have been an opportunity to discover this if you polled the jury?
I'm
Or maybe
sure
not an opportunity to discover the written out void, but opportunity to discover the consistency of the jury's decision.
Yes, and I think had the trial court asked the jury after reading the verdicts aloud, members of the jury, is this your verdict? And they respond in the affirmative, then there wouldn't be an issue here, just because there was that assent by the jurors. But because there was the proper procedures weren't followed, I think the issue is still preserved for this court's review. I'd like to point out to the court Ex parte Cook from the Court of Criminal Appeals. It's a double jeopardy opinion regarding the offense of driving while intoxicated with passengers under 15. There were 2 victims in that case. The Court of Criminal Appeals says that is not 2 offenses. That is 1 offense with 2 victims. Similar to.
Yeah, why wouldn't the unit of prosecution there be driving while you're drunk as opposed to?
It was. That was the unit of prosecution.
Right.
What the trial court tried him on, he was convicted of 2 counts, 1 for each driving while having this victim and driving while having this victim in the car.
But could the state of prosecutor for some type of deadly conduct in that you're drunk and you driving 2 other people around? And then it'd been 2 units of prosecution?
I suppose so, and I think in the
Is it the difference in the nature of the crime with which he was charged?
I think in the DWI statute, it says in there, if you can be charged under this and another statute, you can be charged under both.
Mhm.
That's not present in the aggravated assault statute. So I think that's the distinction there. And I think it's illustrative of there can be multiple victims of a single offense. I believe there were instructions in the jury charge regarding provocation of force, and if you do provoke the difficulty, you're not entitled to defense. So I believe the court will
Is
find
that
that.
something the jury could have considered
I believe it was in the court's charge.
in the charge? So they could have said that. And they could have just looked at the kinfolk that. And I guess the problem would be Mr. Goodman or Walter. I can't remember his last name for some reason. But he may have been with kinfolk, but they they didn't find self-defense on that.
Nah, I think there was some confusion just based on the fact that Mr. Goodman didn't testify at trial and as to where he was and what his association was with the kinfolk was really from hearsay.
Do you agree or disagree that there may have been evidence that there was a plan on behalf of Mr. Paez and the other bandito
I would
when they
dis-
walked in there?
I would disagree, Judge, because it's pretty clear from the video, Mr. Paez doesn't produce a firearm until the kinfolk produce a firearm.
Is that-
And if the point was to what end? I guess it would be to hurt the kinfolk, but he fired 10 shots in a crowded bar or into a crowded corner of a bar, didn't do what they, I guess they were setting up to do. It doesn't, I guess it doesn't,
You said set up, and that's what Mr. Ford was talking about. Mr. Paez,
Yeah.
what Mr. Ford was setting up. Do you agree or disagree with that analysis of the evidence that Mr. Paez was setting up as his colleague was approaching the kinfolk?
I would disagree. I think that he was watching the situation unfold. He's seeing individuals draw firearms and he doesn't produce or fire his firearm until the shot goes off and things proceed from there. Thank you.
Thanks, thank you, counsel. Case submitted and you're free to leave. Totally irrelevant observation, but there was an observation made by someone in our court that Mr. Nunez, you've probably argued in this, well, in front of this court more than any other attorney within this last year. So we continue to welcome you to come, but we're seeing you a lot.
Look forward to being here.
Justice.
All rise.